On Viewpoint today, we will look at the key changes in the Waqf Act, and to discuss this, I have with me two very special guests. Sai Deepak, advocate in the Supreme Court, and also we have with us Kapil Sankla, who is an advocate of the Supreme Court as well. Thank you, gentlemen, for joining me on this all-important issue. Sai Deepak, let me start the program with you first. Let's get a little history as far as the Waqf Act is concerned. We'll go back a little bit, and we'll also try and understand what changes in the new law.
The legislation was brought about for the very first time in 1995 and then subsequently amended in 2013. It had certain provisions which have an impact on the following aspects, which are the specific issues that even the current bill addresses: creation, consolidation, management, composition of the tribunal, effect on third-party rights, and finally adjudication. These are the six broad heads under which I would like to address or compare the legislation as it stood prior to this amendment and the legislation that's just been passed by the legislature with the assent of the president. The problem with the pre-existing legislation was the serious impact on third-party rights, creation of Waqf through user and not just through creation or endowment as we typically understand it. 3, the broad impact of these two provisions on the rights of third parties, especially religious communities. These, I think, were the broad problems with it. And secondly, the ability of oversight either by the state or even by the higher judiciary, so to speak, was practically absent. These are the areas where the current form of the legislation has managed to plug in some of these holes, wherein the problematic provision of Section 40 has been repealed. Then the composition of the Waqf board has been altered to have the presence of both non-Muslims as well as women as part of Muslim members, along with certain representations from the government itself. Considering that it has that Waqf has the ability to receive endowments from non-Muslims, and its conduct also has the effect on the rights of non-Muslims, it only made sense to have the presence of non-Muslims as part of the Waqf board. 2, apart from Sunni and Shia Waqf boards, the possibility of diversity in representations from other Muslim sects, such as the Aga Khani as well as the Bohra sect, have been created specifically in this amendment. And the appeals to High Court from any decision of the Waqf tribunal, I think, is a stellar or salutary provision. If I had to go back with one, perhaps feedback or constructive criticism of the legislation that has been passed, is what does it do with respect to pre-existing claims where the Waqf board has extended a claim to properties that perhaps don't belong to it? And what does it do to these outstanding old claims? That question has been left almost untouched, and perhaps that should have been addressed. But for whatever it's worth, I think a significant surgery has been undertaken of the legislation as it stands.
Absolutely. All right, Kapil Sankla, let me bring you to the picture now. Let's try and understand really as far as this particular issue is concerned. You know, what are your opening remarks? How do you look at the new act?
Well, how I look at the entire Waqf controversies like this, I don't really think there is a political debate around it. I think there is a debate as to property, because the Waqf, as far as it got created, was for property management. Now, various other amendments were brought in, various other changes were brought in, but all of them were to consolidate the property and the possession of the property by the Waqf board, so to say. You know, Waqf basically means confinement. The whole idea is that if somebody gives his property to the Waqf, it is now in the name of Allah and nobody else can challenge it or take it back. So therefore, once the property is gone, it is gone for good. Now, there were various issues with that. One major issue was that somebody could give his property to the Waqf, and then if there's a change of heart, change of mind, subsequent requirement, if his LRs wanted to challenge it, there was no way to challenge it. The second problem was that there was no documentation that was required. And the onus was shifted on the person who wanted to challenge the right of the Waqf over the property. So there were questions in Kerala where somebody found out that thousands of acres were with Waqf board, including a Chola temple, thousands of years, hundreds and thousands of years old. There were other issues as to various temples now being in Waqf property, and the onus had been shifted. And the only way to challenge it, unfortunately, was to go to the tribunal, and tribunal was be all end all, and there was no other way to perhaps go beyond that unless and until you could show certain mitigating factors like, there was a typographical error, the property in fact was wrongly stated, etc. But beyond that, there was no other recourse. The third was that there was an ad infinitum power on the Waqf to come and say, listen, this property is mine. There was no limitation to challenge it. They could come up at any stage and say, now we realize that this property is ours, and the onus is put on you now to prove it otherwise. There were another very interesting case, which was the Jindal case, where Jindal wanted to, for the purpose of mining, there was an old dilapidated building or a thiya, so to say, and some Muslim body challenged it, saying that namaz was, certain laborers, etc., were found in that area offering namaz, and therefore this is now Waqf property. It went all the way to the Honorable Supreme Court, and for the first time, if I'm not mistaken, certain documentations, etc., were asked for. So, in my understanding, this entire dispute is now being given a color of fundamental right, the right of minorities, etc. But I think it is only a right as to one organization saying we have an absolute right over the properties that we have. You cannot challenge it. We will decide what to do with those properties and how, so to say, we would monetize it. There have been various questions. There was an AAP MLA, if I'm not mistaken, who sold off certain portion of certain Waqf land. There was another case where certain properties were sold off for building of mall, etc. So as far as fundamentally the question is concerned, it doesn't actually, pertain to any religious endowment, but it actually pertains to how a property by a certain sect or an organization in that sect will manage those properties.
So it's less about politics, it's less about religion and more about management is what Kapil Sankla is suggesting. So since we are here, J. Sai Deepak, let me bring in another aspect. Now let's talk about management and how the Act helps really in managing managing the Waqf properties and what happens really as far as the Waqf board is concerned and what are the larger implications really.
See, one of the things that I'll just build on Mr. Sankla's point on the issue. So you have to consider one thing. This is one of the subjects where property jurisprudence meets religious endowment. Now, let's address this from a fundamental perspective. Does the central government have the power to, or the central parliament, the union parliament, does it have the power to legislate on the subject? The subject falls under entry 28 of the concurrent list, where all charitable endowments typically are accommodated, and therefore both the state and the center have the power to pass laws, and for a fact, the center's power will prevail under the doctrine of colorable legislation if there's something contrary to it. Now, the second thing that you have to consider is when it comes to property jurisprudence, even if it is treated as a matter of fundamental rights, the manner in which the Waqf board existed prior to this and the manner in which these provisions facilitated the assertion of rights by members of one community had a direct bearing on the fundamental rights of other communities as well. Assume for a moment, if under conventional property principles, somebody had to lay claim to your house, he would have to first of all show that the property belonged to him, that there is some title deed which has been issued in his favor, and he would have to satisfy some de minimis principles to explain why he has the right to assert ownership. In stark contrast, the Waqf Act was a serious anomaly where it expected the person on whom the claim has been made to prove that no claim lies and that the property belongs to him or her for that matter. Now, these are certain fundamental aspects which are violative not just of those evidentiary principles or burden principles that we take for granted when it comes to conventional property jurisprudence. It also overturns the right of property of third parties. So if somebody truly wants to characterize this entire issue as a question of fundamental rights, it's as much a question of third-party rights as much as it is a question of the rights of members of one particular community. Two, if you look at the global map in terms of how these Waqf Acts or these legislations have been managed or administered in even Muslim countries for that matter, or countries which are Islamic republics, you will see that there is a very clear state oversight for multiple reasons. One is to prevent mismanagement within, which means you give it in the name of the community, but at the end of the day, the community does not stand to benefit for whom the property has been endowed. Or assume for a moment that rents are supposed to be collected from certain properties, which are Waqf properties and which have been leased out, but no rents are being collected. These are issues that the government has a legitimate right to step in and take a look at. no amount of minoritarianism can take away the power of the parliament to create a legislative oversight and an executive oversight over management of such vast swathes of land. If you were to go by the existing statistics, you're looking at what, 32 lakh acres. That's a massive number in terms of land corpus. And I don't know of any body other than the Union of India and perhaps the Indian Railways which has access to this kind of land corpus. And if it has rights, if it has an effect on, let's say, the rights of members of the community as well as third parties, I don't think politics is the question here. The question is of legitimate rights and concerns. Now, coming to the question of management, what they have done here is also to create a public portal where the proceedings of the Waqf board and any decisions taken by the Waqf tribunal, so to speak, can be made public for third parties to have access to it. And if any third party rights are actually affected by it, they can actually approach and say that this should not have happened in the first place. Now, this is not an aberration. Any lawyer worth his salt will tell you, if parties A and party B are fighting with each other over a certain property, and in the process of that fight, the court ends up passing a certain order that has a direct impact on the rights of property C of a third party, then that particular person has the right to enter proceedings and say, if these two people are fighting, how did you pass an order which has an impact on my rights? But that is possible only if that order becomes public, so that people know that such an order has been passed. But if the proceedings of the Waqf board or the tribunal are quasi-confidential, with people not knowing what exactly is happening there, how do you then enable transparency and how do you enable access to justice? So these are certain aspects that they have addressed. Also, what they have done is the government has the right to appoint non-members or non-Muslims as part of this particular committee, which ensures that there is some diversity of representation. I'll give you a simpler comparison. People can say, can a non-Hindu be appointed to, let's say, the temple management board? In such a situation, how can you appoint a non-Muslim to the Waqf board? The difference is the temple management board primarily concerns itself with the management of the temple, whereas the Waqf board is looking at real estate and not the running of the mosques. That's point number one. Point number two, there is a specific legislation wherein the government actually extracts a cess from temples for the services, so-called services it provides in terms of management of temples. That is not in the situation when it comes to Waqf board here.
Right.
The government is not doing any kind of rent seeking or rent extraction from this body. All it is saying is the manner in which you've been operating over the last few decades, so to speak, comes at the expense of transparency and third-party rights. Let us put that house in order so that some kind of balance is struck between your community rights to endo properties in the name of your deity and what does it do to third-party rights. I think that's all there is to it. To make this an issue of minority rights, according to me, is to do injustice to the balance with which this entire issue has been addressed.
All right. So it's all about transparency is what Sai Deepak is suggesting. It's all about better management. It's all about bringing things under control. All right. Kapil Sankla, let me bring you into the picture once again. I know you said that this is less about politics and more about management. But nonetheless, let's discuss this particular aspect as well, because there are certain political parties, MPs of certain political parties have taken this matter to the court. They have raised objections and they have said that this really is not the way to go. How do you look at it and what do you see transpiring?
See, I just asked them what is the alternative. I'll tell you two stories. I've been associated with two cases which are very close to my heart. One of them is the case pertaining to the Auroville Society in Pondicherry, Puducherry, in which the government took over the Auroville land and the Shri Aurobindo Society, saying that they would have an officer there to manage the funds, the assets, etc. Today, when I go there, I have to take a parchi as a non-ashramite to go there and perhaps have a meal there, which for many would be prasad. If I go to Auroville is now being managed by an IAS officer and certain people which have been appointed by the government. Second fact, I am the lawyer in the Turkman Gate case, where what had happened was that a case was filed against the Mutwalli. The Waqf board was made a party. The state Waqf board said this is not our Mutwalli, filed an FIR against the Mutwalli. And then the Mutwalli and the Waqf board got it together because they realized there were hundreds of tenants who now could have filed a case saying that they never came under the Waqf board. The Waqf board suddenly recognized the Mutwalli and now we are fighting against the Waqf Board and the Mutwalli, against whom there is an FIR by the same people saying that he is a third party, nothing to do, unrecognized fellow. Now, in the light of the same, you would appreciate that these people in Turkman Gate have been there since partition and they have no document. Now the owners have shifted to them to prove that this is not Waqf land. So you understand how unreasonable, how illegal the entire concept was. I will tell you yet another case. Somewhere in down south, what was happened, there were mass conversions. And after mass conversions, most of the people were asked to give their land, or it was claimed that they've given their land by Waqf by user. Now the law that is now being sought, has been introduced, is that a person who wants to give his land by Waqf for user has to be a practicing Muslim for last 5 years. How does this encroach upon anybody's fundamental right? Now, the other part I was telling you about the Chola temple and other temples was this, that thousands of acres have been taken over, claimed by Waqf that it is our property. There is no record whatsoever. No record is to be kept by Waqf board. You only can go to the tribunal. And therefore, now the law is, listen, in digital India, you have to digitalize the record. Let there be a centralized digital portal. That itself is sought to be challenged. They are also saying that as far as the tribunal is concerned, there would be a judicial officer amongst other people so that a judicial representation is there. I don't understand how you can politicize this. Now you're also saying, and this is also something that is happening in all Hindu temples, etc., etc. I mean, it's nothing new, because also in many Hindu management, there are government appointed board members. So therefore, as far as all those questions are concerned, they've already been answered by various precedents. What is now being sought to be said is this encroaches upon our religious independence. No, it doesn't. It only regulates the properties that are being handled by a board. The income from those was supposed to be for the betterment of the Muslim community. Unfortunately not. The Satya report says only there is an ROI of 2% from the various properties that are owned, and the ROI should be between 9 to 10%, the very least. So where is that money going? It is going in the hands of unscrupulous netas who are basically handling the Waqf properties in the garb of religious independence, and this has to go. That is all this act is all about.
All right. This really has to change, and the act brings in that change, and we are going to see better management in the near future, and of course in the days to come, is what Mr. Kapil Sankla is suggesting. Sai Deepak, let me take up this point once again. You know, you addressed the issue of non-Muslims being part of the Waqf board, the issue of government oversight. Now, this is another aspect that has been spoken about quite often, especially members of certain sections of society and politicians as well. You know, Mr. Sankla also touched upon that particular aspect, brought in the example of Puducherry too. Government oversight, why is this really such a contentious issue and such a big problem?
Okay, I'll answer this question differently. Assume for a moment that the pontiff of a particular mutt or a seminary passes away, and the mutt is in possession of, or it has at least thousands of crores of property in its name. The government actually has the right to step into the picture to see that that particular money is not misused or siphoned off or pilfered away. This is in the context of a private seminary, which is protected both by religious rights as well as privacy of property. In the context of the Waqf Act, massive swaths of land are being given away in the name of the Waqf. The entire regimen of administration was such that sunlight would barely manage to enter the portals of the Waqf proceedings. You would not know whose property is being taken. You would not know what are the principles that are being applied. And since the burden of proof has been completely turned on its head, nobody has access to any kind of principles of natural justice to say, if you assert your rights with respect to property over which I have documents, the onus is on you. And the example that Mr. Sankla was giving was of a 1400-year-old temple suddenly being claimed in the name of the Waqf, where the temple and the faith that it belongs to, I mean, they far predate the faith to which the Waqf community actually belongs, or the Waqf board actually belongs. These are the kind of instances that you're actually looking at. So as far as I'm concerned, the track record of this entire tribunal has been one of tribalism. Unfortunately, the tribunal functions like a tribe. And therefore, the presence of those parties who have been affected in the long history of the Waqf board and the Waqf tribunal is legitimate way of addressing that particular issue. Now, you make the proceedings public. You also set an even playing field by ensuring that traditional principles of property are applicable to it, and there is a representation from across the board. How does that in any way affect if you have nothing to hide? If you have nothing to hide, you should not have a problem with the presence of somebody else. Although this may be a religious endowment, it so happens that this religious endowment can come at the expense of third-party rights. To just build on what Mr. Sankla said, Waqf by user is such that you can claim certain properties through a user without even showing what is the kind of user that you're looking at, whether principles of adverse possession of property actually apply to you. Do you at least satisfy those principles to say that although somebody has not endowed it in my name, through user it has become mine? What has happened in the process? Mazars have been created, shrines have been created overnight in places of either religious significance or of strategic importance. Please take a look at the latest instance where suddenly you can see a lot of green mazars cropping up around sensitive locations such as the upcoming Mumbai airport, okay, or around the Mumbai airport. When you look at this, you end up wondering whether this was meant to facilitate ownership of community property for the benefit of the community, or does it have other implications for third-party rights as well as national security, dare I say it, because if something is happening without scrutiny, and when scrutiny or simple transparency is seen as an attack on fundamental rights or the religious identity of a particular community or the religious rights, then I must say that you're using legitimate provisions of the Constitution in an unfair way to shield scrutiny of what exactly is going on. I refuse to buy the argument that a community or a body which is sitting over a land bank of 32 lakh acres can operate without the oversight of the state when it has consequences for national security as well as for third-party rights. I refuse to buy that argument. This is not a communal argument. It's a perfectly justified argument. When Satyam was in doldrums, the government stepped in to set the house in order and stepped out. If you can do this with a private company, if you can do this under Article 31A, which permits the taking over of even private property in the interest of public, what stops the government from putting in place a simple, better, transparent regulatory structure which ensures that there is more transparency in its operation? Has the government repealed the Waqf Act? Has it done away with the concept of a Waqf altogether? Has it taken away the right of representation of Muslims in it? Has it populated the tribunal with majority of non-Muslims? If the answer is no to each of these questions, really what are we crying about here?
Right. Absolutely. Okay, points well taken. Kapil Sankla, coming back to you now before we get closing comments from both panelists. As far as this matter is concerned, I know it's a difficult question, but it's taken to the courts. With your vast experience in dealing with various matters in the courts, how do you see things transpiring? Where do you see this headed?
Well, that's a very difficult question to answer, but how I'm looking at it is, if the courts also believe that this is not so much of a religion issue pertaining to the minority rights, but about property management, then perhaps they would look into certain material questions. And the material questions will be, how are the properties being managed till now? Under what circumstances the properties have been sold or transferred to third parties? And what are the returns or the income which is generated? What is the purpose and what is being utilized for? I think these are very material questions that require answering today, to actually see whether the Waqf itself was established for the purposes and whether it's doing what it was established for. The second thing I really think that the court will get into is also draw a parallel with various other issues. I've already spoken about Puducherry. We've spoken about other issues pertaining to, for example, the Chola temple. We are talking about the Turkman Gate case and various other cases. Now, these are very material questions because it is very easy to bring any argument as far as minorities or special act or special laws are concerned, or for a certain sect, to say that this is an encroachment on the fundamental rights. But here, whether the encroachment is on the right of a person to profess religion, or whether in the garb of those arguments, certain other unscrupulous issues are being tried to be hidden or to be brushed under the carpet, is something that the courts will see. So let us see how it pans out in future. Right now, how I see is most of the arguments are on fundamental right and minority rights.
Absolutely. All right. Very quick closing comments now from both my panelists with what next and the best way forward. Very limited time. So in 30 seconds each, please close the show for us, starting first with you, Sai Deepak.
I think that this legislation has been passed after extensive consultation and representation from across the board, from all stakeholders. Two, although I believe that this is a fantastic step in terms of what has been done, I am certainly of the view that more could have been done, particularly to set the house in order and to create an even playing field for all communities concerned in terms of perhaps addressing questions with respect to past ownership. Three, I genuinely hope that the judiciary approaches this from the perspective of applying the standards of conventional property principles and asks, what is it that has happened in the context of the Waqf Act, which requires judicial intervention? If all it has done is to infuse those very same principles which have been endorsed by the Supreme Court over and over again in multiple and thousands of property matters to religious property matters, should religious property matters be exempt from the application of conventional property principles? That should be the straightforward question.
And Kapil Sankla, please close the show for us with your concluding remarks and your final word.
I believe that the Sachar Committee report, which I was talking about 2006, was a wake-up call to reform the Waqf governance. Amendments like the 2013 and the other amendments, etc., sought to convert the Waqf from a dormant institute into an engine of community development. However, it failed miserably. And now I think what has been done is that instead of looking at all the ills certain sectors are trying to are politicizing the issue, and unfortunately trying to make this into minority appeasement argument, which should never be permitted.
All right, we'll have to leave that. Gentlemen, thank you so much for joining me on the program and putting things into perspective for us. Much appreciate you, with your thoughts on Viewpoint today. All right, what's coming out of this discussion is that the new Waqf law is less about politics and religion and more about management. The government is stepping in to set the house in order and bring about much required transparency. It's all about setting up a robust regulatory structure, which is the need of the hour. That's it on this edition of Viewpoint. See you again next time.